Thank you so much, Jeff, and thank you for all the accolades. Hey, I'm so glad to be with you. I hope everybody had a wonderful summer. It feels like we're just starting the season again. So welcome and thank you for joining us. For you CAMs out there, no, you don't get a credit or you don't get your legal update credit, but it is definitely very important for you because there's a lot of things that impact you as a CAM for condominium associations. And there's a few things on here that also apply to cooperative associations, but you lucky co-op directors out there are not required to take annual updates to your certification. So good for you. There were a lot of activity in the 2025 legislative session. A lot of things that we were happy that were ultimately defeated and did not pass. And so, of course, some of that is likely to come back again, like always. But if you keep in touch with us, if you're on our mailing list, then you will receive updates about what's happening in Tallahassee to the extent that we can do that. So let's just get started. This is me. I'm Lisa Magill. Hopefully I know most of you, or some of you at least out there, and I've been working with Kay Bender Runbound for several years now. Really enjoying the experience, and hopefully and hope that you are utilizing our services. If you're not, then we're happy to provide you with information about the firm, so should you so desire. That's not part of the class, obviously. Our firm handles everything associated with community association representation, including all the items that are listed here, and basic corporate representation. So you as board members and you as CAMs have an idea of what is right or wrong, how to remain in compliance with regulatory requirements, how to navigate the tumultuous, waters of dealing with owners and contractors and vendors and management and what have you. We're happy to help you with all of that stuff. So let's talk about this law. It's HB 913. We're going to start off with talking about you, CAMs, if you're out there, community association managers and management companies. Now, what you'll find in this presentation is there is a lot of material. So what I've tried to do here is include some synopsis slides, so I can go over the major theories or the major points that I think that is really important for you to know, and hopefully be a little bit easier for you to remember. But you have all of the content in the slides, and you will receive a copy of the presentation that you can print out and have as a ready resource. And we hope you do that. So here is one of my synopsis slides. So CAM licensee requirements and restrictions. Now,
Hey, Lisa, I'm going to interrupt. We're not seeing the slides yet.
Oh, why not?
Thanks, Steve. There we go.
Oh, sorry about that. I apologize.
All right, back to you, my friend.
Yeah, I apologize. So you were just looking at my mug this whole time. So I definitely apologize for that. So yeah, CAM licensee requirements and restrictions. So due to some complaints over the years to the legislators, now if your license is revoked, you cannot obtain a CAM license, own or work for a management company for 10 years after the license revocation. All of you CAMs must have an online account with DBPR. The online account, you will list what communities that you serve. And contracts, this is important for both CAMs and for you board members out there, that the contract now must have specific disclaimer language that indicates that the CAM or the CAM firm, the management company, must adhere to the professional standards. I don't know if you remember, but last year, the CAM rules were modified for HOA. So if a CAM was working with an HOA, there were some new requirements. Those requirements have now been transferred over to the condo world. So you have to attend, if you're working with an association, you have to attend at least one association meeting in person every year. One association in person every year. And the owners are entitled to information. So the owners are entitled to the contact info of the CAM. If you're working with a management company, the management company has to designate a CAM that's responsible for that community. So even though you may work as a team, someone's going to have to take point and have their information listed on the association's website so that it will be available to unit owners if they have problems that they need to contact the CAM. And then also, which they were always entitled to it, but owners are entitled to a copy of the contract with the CAM or the management company. This new law basically puts the onus on the CAM or the management company to provide access to that contract. But as well, you know, that is a record, that it was an official record of the association, regardless of what type of association you manage, and it would be available to unit owners regardless. So now it's just a matter of just reinforcing the ability of owners to obtain a copy of that contract. Really, what the purpose is so that the owners out there know what you're tasked with as a CAM. You know, they may think that you're responsible for the sun rising in the morning and the garbage being taken out in the evening. But again, you have specific responsibilities based upon your contract with specific associations. So that way you can delineate those responsibilities and hopefully try to lessen some of the chatter that is not necessarily within your responsibilities. So here is where we get to the details. And what I'll do is I'll go through these slides far more quickly because I've actually already discussed this issue in the grander scale. So this slide says about the 10-year period effective after the revocation. This new one says creating and maintaining an account with the department. You should have already received some kind of email from DBPR or a note that you have an account with the department regardless because of your licensee status. So here, this contains all the details of what you have to identify on that new registration provision. And here, this talks about those professional standards. So the language that I talked about before is right here. It has to say, community association manager shall abide by all professional standards and record-keeping requirements imposed by Part 8 of Chapter 468 Florida statutes. 468 is the professional standards and licensee requirements for community association managers. And of course, the contracts between associations and management companies or between the association and the CAM cannot waive certain rights or liabilities. So you can't waive your gross negligence, you can't waive certain liabilities. But let's talk about conflicts of interest and disclosure requirements, because this was another big issue that they addressed in Tallahassee, not only on the CAM side, but also when we start talking about the milestone and the repairs that are necessitated as a result of a milestone report. So the CAM contracts always have to disclose if there's a beneficial relationship. Beneficial relationship has been defined a little bit more succinctly as if you're receiving a referral fee, a monetary benefit, a profit sharing, any type of way that the CAM or CAM company is going to benefit from the relationship if the association utilizes those services. There's now a presumption. So this is something for you to pay attention to. If the CAM or the management company proposes to perform services other than management services, there's a presumption of conflict. What does that mean? That means you have to give the disclosure. And that really means that you have to give an alternative bid or a competitive bid. So there may not be anything wrong with the management company or an affiliate or a subsidiary of the management company performing other services, landscape services, pool maintenance services, pest control services, all types of concierge services, all kinds of different things. It's just a matter of disclosing that information, disclosing it on the contract, disclosing it when the board actually votes to approve that contract or approve that service, and ensuring that there are some competitive bids on file so that all things are compared equally. And same thing with bidding for the association for other types of services. If you're going to present a bid from one of your your vendors or one of your industry partners for which you receive some type of beneficial relationship, you have to provide an alternative bid if the cost exceeds $2,500. And again, I think that would probably be your practice anyway. Just wanted to make sure that you were aware of all those. There's a question here, actually. So to the extent that I can see questions and I can answer them right away, let me do that. So the question here is actually a good one. If a CAM is current with license, but they don't manage a property, does this need to be noted with DBPR? Sure, they'll just say none for right now. I mean, there are certain times when you may not be managing a specific property. You may be working at admin. You may just be taking a break. Go ahead and just say there's none. And then when that changes, you'll go up and you'll update the information that is online. There's another question here that's also interesting, because the question is whether or not your existing contracts need to be modified. Again, I don't really know the answer to that question, but I've been suggesting is every time you renew a contract, so if your contract is coming up for renewal, definitely add all the disclosures and all of the other requirements, the requirement for the in-person meeting, the requirement to designate a CAM that's responsible for the community, the requirement to list that information on your website if you have a website. On the agenda, I think I talked about this, but all conflicts or potential conflicts must be disclosed on the meeting agenda. So where you're going to vote on a contract with an affiliated company, you just put it on the agenda, vote to approve landscaping contract, quote, open quote, affiliated entity, close quote. And then at the meeting, the CAM or the representative of the management company or the representative of the company that's proposing to perform the services can explain, hey, we do have this beneficial relationship. We work together on many different properties, and they can explain how that is beneficial to you. And the owners that are that are attending can ask questions. Well, what does that mean for us? How does it change our relationship, or what have you? The good thing here is that if there's not if there's a failure of disclosure, and it's later determined that there is some type of a beneficial relationship, at that point, the association can go ahead and cancel or void the contract. So you're not responsible for remaining with a vendor management company if you feel that they have been less than transparent with you. Next question on here, we're going to get to this, but is the DPPR site up and running for Condo Association Board to register? I'm going to get to it. I actually do include links in here for you to not only to register, but the DPPR publish some tutorials or help desk type links, because it was a little bit confusing to some of the people when they were trying to register. So this is going to have all the detail. So as I said, I'm going to have that little synopsis slide. Here's where you have that detail. So it's easy for you when you go back to look at these, that you'll have all of the information that we just talked about. And here's the conflict of interest issues. And here's where I said the term compensation means any referral fee, other monetary benefit, which provides products or services to the association, or any ownership interest, proper shaving or arrangements, and the like. And this is all just keeping everybody above board. Again, if this goes over the fact that you need competitive bids for services exceeding $2,500 if you're going to present a bid from an affiliated or a company with which you have a beneficial interest. It has to be listed on the meeting notice. And at some point, if the association later learns that there's been an undisclosed conflict, that the contract is voidable. So this is a very big issue for you as a CAM or management company. You want to make sure that everything is disclosed properly. So let's talk about the milestone updates. Hope a lot of you have already done your milestone inspections and are already either completed with your repairs or are primarily completed with the repairs, thankfully, right? I mean, that was a very, very big obligation on the part of many associations that were just not familiar with these inspections. In Miami-Dade County and Broward County, we've had these safety inspection requirements for several years. Miami-Dade County's had it for over 20 years, possibly even longer than that. So at some point, community associations and community association managers knew that the building was going to be inspected and there were going to be repairs to be made. Now, if you are on top of concrete restoration all the time, every 5 years, you're doing concrete restoration. Every 7 years, you're doing your painting and waterproofing. You're doing your roof. You have a maintenance contract with your roof and you replace it. As soon as it shows any signs of deterioration, then you might not have had significant work. But many associations did. I mean, and it was a very, very expensive project, sometimes very painful project, sometimes very long-term project. Some of these projects I know are taking 3 years, and to live in a construction zone for 3 years is not the most pleasant. It really creates a lot of strife among the residents. There's a lot of strife among the relationship between the manager and the residents. And also, everyone's got a different opinion about how work needs to be performed, whether it needs to be performed, how expensive it is, and what have you. So the legislature did give a little bit of a break, but it doesn't apply to you that have already gone through the project. Now it's clarified that the inspections are required when there are 3 habitable stories. So in the past, you had the 2-story condo over the parking, that was considered a 3-story. We were telling our clients with those kinds of configurations, hey, you need to go get that milestone inspection. I don't feel bad about it because you know what? There's nothing wrong with a milestone inspection. In fact, it's a good thing. So if they didn't have work that they needed to do as a result of it, all the better. If there was work that they needed to do as a result of that inspection, good. I'm glad they found that. I'm glad they got that work done before it was too late or before it compounded problems that made it even more expensive later. But let's talk about that disclosure issue. Remember that conflict issue? Very big issue in Tallahassee as to who was going to be doing the inspection and who was going to be doing the work. So if you have an inspector, the inspectors have to be engineers, licensed engineers, licensed architects, or people that have the designation as reserve advisors or professional reserve analysts. And those individuals work for firms, typically, or they have their own firm. And some of those firms have also construction components or are related to construction contractors or other types of service providers. So the inspector, if the person coming to inspect, when you get the bid to do the inspection for the milestone, they have to disclose whether or not they intend to bid on the work that is going to be that's going to be specified as a result of the inspection. So they have to make that disclosure. What I would expect them to do is just disclose that they have a concrete restoration company, or they're affiliated with a concrete restoration company or affiliated with a roofing company, and at the end of the milestone inspection project, you'll decide whether or not you want to invite them to bid. The same thing is true with the bidders later. So you have your inspection done, you get your report, your engineer or architect prepares the specifications for the repairs, and then gives you a list of companies to go out to bid. Not only do they have to make that disclosure, whether there's a relationship with the companies that they put on the list, but the bidder, if the bidder comes in and has a relationship with the inspector or some kind of beneficial relationship with the inspector or the inspection company, they have to disclose that. And the law now requires the local enforcement agencies, the local building departments, to assemble a whole host of information and furnish the DBPR with statistics, because there are wide differentials as to what work was required, how the work is specified, how much work is specified. I can understand some trepidation on the part of board members or on the part of unit owners. Hey, why are they telling us we have to, do every nook and cranny? I mean, they're really being excessive with this. But think about what happened a few years ago. You had a loss, you had a collapse of a building, and everybody was held responsible. I mean, the engineer that said that repairs were necessary was held responsible. There was responsibility allocated out among everybody that basically had touched that building. So now from the engineer or the architect's standpoint, they want to include everything. They don't want to be in a position where something is omitted and something goes wrong. So they at that point, they're going to include everything in the specification or the defect report, the milestone report, and you are therefore obligated to move forward with those repairs. We're going to go through exactly what the DBPR wants to collect. So here we talk about mandatory structural inspections. Wait a second. I think we just did this. Yes. Sorry, I must have made a mistake. I didn't talk about this. Each municipality or the county commissioners has to adopt an ordinance that talks about the schedule for repairs, when the repairs need to be commenced, how long, what a time frame do you have to have the work performed. And of course, those ordinances must have allowances in case the work takes longer than you think that it's going to work. Here, the architect or an engineer must disclose their intent to bid on any of the services. Again, the bidder has to go ahead and say that there is any interest with the firm or the entity that provided the milestone inspection, and the contract is voidable if there's that failure of disclosure. So these are really, really high penalties for failing to disclose, and there's no reason not to disclose this information. So the question is how the requirement is enforced and timelines for completion. So we're going to talk about that a little bit later, because the DBPR authority has been expanded to investigate and address complaints related to the failure to perform milestone inspections and/or the failure to perform the repairs that are specified in the milestone inspections. And as far as like actual physically having the work done, the timeline for physically having the work done, that really is subject to the local building department or the authority having jurisdiction. So here's the information that they want up in Tallahassee. Well, the legislators wanted it, so now the DBPR has to assemble it. The only way for the DBPR to assemble it is to get it from the local building officials. So the number of buildings required to have a milestone inspection within that agency's jurisdiction, the number that have already completed it, whether extensions have been granted, whether a phase 2 was required, whether the phase 2 was complete, the number, type, value of permit applications. Really, they want to see the statistics. How many people are having work done as a result of these milestone inspections? How significant is that work? How expensive is that work? And what do we have out there in our whole entire state of Florida as far as unsafe or uninhabitable, as determined by the milestone inspection? So what are we looking at here? Are we looking at a bunch of properties that really should not be occupied right now? Or is everything pretty much safe? It's just that are repairs that need to be done. And that information they'll be able to compile, and they'll be able to provide the legislators in Tallahassee. And who knows, maybe that will result in some modifications to the milestone inspection requirements. We don't know yet, but really the data is necessary for them to be able to analyze what they think is appropriate. So the law, we're all talking about condominium associations here. we're going to go into some of the more specific details. Here's the big kicker, big kicker, video conference meetings. Now, in my opinion, video conference meetings were already allowed. In my opinion, there was no need for there to be a physical location for which the meeting was going to be held. If you're going to have a meeting via video conference, so long as you provided everyone with the capability of participating. So the people that were not computer savvy or did not, want to use computers or cell phones to log into a video meeting could at least call in, use their telephone call in and participate, hear everything that's going on and speak at the meeting. So now the notice, there's a little bit more restrictions associated with this. The two big restrictions are there needs to be a physical location for these meetings, which may vitiate the efficacy of a video conference meeting altogether. I'm still a very big fan of them because in my experience, it's enabled many more owners to participate in their association operations. The other big kicker is that the conference must be recorded and the recording preserved as an official record for 1 year. So this is very different from the old rule that we had in the Florida Administrative Code about the audio recordings of board meetings or membership meetings. In the Administrative Code said that if you recorded a board meeting for the purposes of preparing your minutes, then you could destroy the audio recording after the minutes were prepared. Because really, that's what the purpose of having the recording, so that you could either check or verify that the minutes that you took are accurate, or could just prepare the minutes based upon the recording. Now they must be recorded and preserved as an official record for a year, and either the recording or a link to the recording posted on the association's website. For the annual membership meeting, in my mind, this doesn't make sense, because now it says the quorum of the board must be physically present at a location where the annual meeting will be held. Well, you don't even need a quorum of the board to appear or participate in order to hold your annual meeting. Remember, your annual meeting is a membership meeting. You need a quorum of the members. So if that's 50% of the members, and you have 50% of the members, even though none of the board members decide to show up, you can go ahead with your annual meeting. You just have to appoint somebody to be the chair. Now, if you're going to do it via video conference, then you have to have a physical location for the meeting to take place, and you have to have a quorum of your board members physically present. I predict this is going to reduce the number of associations that hold their annual meetings via video conference. Now, this doesn't affect you that have electronic voting. So you can go ahead and have your electronic voting and have your annual meeting the way that you've always had your annual meeting. Your electronic voting is not the video conference. So the people that vote electronically are still counted as being there for quorum purposes, and they can go ahead and vote. Same requirement, must be recorded and maintained as an official record. And then same thing with regular membership meetings other than the annual meeting, recorded, preserved for 1 year, and the recording uploaded to the association's website. I say on the slide that unit owners are permitted to vote electronically. That's not really well, there's two issues to talk about. We're going to talk about it in a little bit, but there's a push here to enable owners to be able to either vote electronically or vote via email, and the email is a little bit convoluted. But let's talk about the details, or I'll give you the details of what we just discussed. Video conference is described, must be the physical location, and has to be recorded. And that's really the most important thing, that you have these meetings recorded, and the recordings are posted on the website. This slide pertains to a non-residential condominium. I'm going to skip that because I would assume most of you are are either leaders or managers of residential condominiums. Non-residential condominiums can include like docominiums, can include like office park condominiums, that kind of things. We talked about the CAM responsibilities and the new requirements. Now we're going to talk about the association responsibility with respect to its relationship to its CAM or its management company. Obviously, you can't hire a management company or manager that's not licensed. Okay. So as the director or the officer, if you're entering into a contract, you have a duty to investigate and verify that they do have a license. If the license is suspended or revoked, you're now able to terminate the contract. And you terminate the contract, you're not liable for any damages as a result of the termination. You're only responsible to pay for the work up to the date that the license was revoked or suspended. And the same thing is true with respect to a management company. I haven't seen a management company itself lose its license, but I'm sure that that may have happened and is possible. So official records and website. The reason I point this out is because when I have issues with the DBPR investigations, they're practically all related to official records retention, records availability, the roadblocks, if that's what you want to call them, to access to records. And conversely, on the other side, the frequency of record requests, the labor associated with like record requests, the cost and expense associated with record requests. So every year we see something when it comes to official records. I think you know already that the minutes must be maintained indefinitely. That was added to the law last year. The website has to have the minutes for the last 12 months. The video meetings must be recorded and maintained for the year and also available on the website. And for record retention purposes, financial records specifically now always include, which I thought they did before, but bank statements, ledgers, invoices, transaction receipts, and deposit slips. So sometimes people actually want to see the source materials rather than the reports that are prepared by your bookkeeping accounting firm or your management firm. Now, I don't know if you know this, but associations are required to have sufficient copies of the governing documents and the Q&A sheet available for people available for people that say, hey, I want to come in and get a copy of the governing document. So it's not as if they have to come and do a record inspection, then request copies. You're supposed to be able to have copies readily available so you can just give them a copy, and then you're able to charge whatever your actual cost is for that copy. Now you also need to have the most recent year-end financial statement, so that's your audit or your compilation or your general ledger of receipt and expenditures, and the most recent budget readily available. So that package of materials has to be readily available so that somebody wants it, you can just go ahead and hand it out to them. This year, they've changed the standard for penalties for failing to honor the records access, made it a little bit more specific. So to show wrongdoing on a part of a director or officer who is accused of failing to allow owners access to records. Important for you guys out there, condos with 25 or more units must have a compliant website by January 1, 2026. So if you haven't done it yet, get on the stick and start doing that, because it may take you a few minutes to upload all the documents that you need. Jeff, did you want to add to that?
Just a quick thing. So good opportunity if you have a refresh your voice with a drink of water. Folks, you don't have to type into the Q&A that you're here. We can see that you're here. If you can type into the Q&A, you properly entered, so you do not have to do that. Another thing, the reason I am not answering all the questions, I'm only answering questions that are not attorney related. So I'm not ignoring you. Just wanted to inform you all, because some of you are asking why some are being answered and some are not. So Lisa will address some of the questions at the end. Just remember to keep it to the point and on topic and not association specific, and we'll answer a few of them at the end. Thank you.
Thank you, Jeff. And there are a bunch of questions up here, and they're kind of all over the place, but one relates back to the milestone, and it says, does a two-story building need a milestone inspection? No, you've been relieved from that milestone inspection requirement. Now, if you're in Miami-Dade or Broward, you may still be subject to the building safety inspection requirements, and some of the municipalities have adopted their own ordinances requiring building safety inspections. So again, it's just a matter of checking with your local building department if you're outside of Miami-Dade or Broward. But another important issue when you talking about websites, you have to have your documents. Once something becomes an official record, it has to be posted within 30 days. So that's all your contracts, that's all your insurance policies, that's basically all of the other documents that you have as far as the documents that must be posted on the website. Uh, Again, for meeting notices, you still have to post them in advance, 14 days in advance for meeting notices, and 7 days in advance for any documents that are going to be voted on at a meeting. And for board meetings, obviously, you have to post the meeting notice whenever, whatever the time frame is for that particular notice, whether it's 48 hours or whether it is 14 days notice. Now, you also need to post affidavits on your website. So when I was thinking about this, I was thinking, what affidavits are there that are official records? I mean, obviously we know about the meeting notice, distribution of meeting notice affidavit, but what other affidavits are out there? So I did a little search. So you have to have an affidavit confirming distribution of the financial report, the year-end financial report. So not only do you distribute the financial report, somebody who's undertaking the distribution has to sign an affidavit. You have to keep that affidavit on file, just like your affidavit of mailing when it comes for a meeting notice. You have to have an affidavit acknowledging receipt of the completed structural integrity reserve study. Now, for when you're engaging, before you can start collections with a law firm or attorneys or a collection agency, you have to have the notice of late assessment affidavit, because now you have to send people notice of late assessment and an opportunity for 30 days to pay before they're assessed or charged with any attorney's fees. And there's an affidavit of mailing of that. And then there's also now an affidavit, because we're going to talk about email ballots. There's an affidavit attesting to the fact that you checked the email address that you designated for receipt of email ballots. So those are the affidavits that need to be posted to the website. And those are affidavits that you may not have, you don't think about other than the affidavit of distribution of meeting notices, because I always encourage clients to, when they prepare their minute books, that they have a copy of the notice of the meeting, with the agenda, obviously, an affidavit of notice of the meeting, if an affidavit of notice was required for that meeting, and the minutes, and any documents that are associated with the meeting or that were voted upon at the meeting, all as one document. So when you're talking about August, you're going to have the meeting notice, the affidavit, the minutes, and if you have discussed correspondence, you voted on a contract, you'll have that all in that one document, and that's the meeting material for the August meeting. So this talks about the official records. I talked about the financial records include bank statements and ledgers and those affidavits that I just mentioned. Here is the change standard for, oops, I'm gonna go a little bit quicker here, but you have to have and we already talked about this, the video recordings and the minutes. Financial reports. So the criminal penalties now have been modified to willfully, knowingly, and intentionally. Financial reports, thankfully, extends the deadline from 120 days to 180 days. You can deliver the reports by mail, hand delivery, email, fax. It says as the member requests, but I've likened that to the member's preferred method of contact. And you have to have the affidavit of mailing or delivery. And same as we talked about last year, you can reduce the financial reporting with the approval of a majority vote of the entire membership, but you can only reduce the financial reporting 1 year for 1 year. So every other year, you're going to need to have the financial report that's required by your level of income. There's been some changes to the ability to invest association funds. Really doesn't make that much of a doesn't really change things that much, but I think we will see several changes to this going forward. So pay attention to what happens in the legislature when it comes to investment. Obviously, you have to make prudent investments. You have to make safe investments. So you're going to want to work with financial advisors or people that are familiar with financial matters in the most prudent way. And you're going to obviously want to announce that information to the membership, or at least make it available so that they know that you're properly safeguarding their money. The bylaws, we talked about the video conference bylaws, unit owner meetings, we talked about the requirements for unit owner meetings, budget meetings. This is a big change. If you're going to propose a budget that is in excess of 115% of the year before, meaning that it's more than 15% more than the previous year, then you have to propose an alternative budget that does not include any discretionary expenditures. Now, I know what you're going to say. There are no discretionary expenditures. What do you think? We're doing this for our health? Everything that's in our budget is a necessary expenditure. When you calculate, and this law used to be that if you adopted a budget in excess of 115%, the members had the ability to petition the board to adopt an alternative budget. Now the board itself has to prepare an alternative budget, but when you calculate the 115%, you take out the items that are listed below: the reserves, the structural integrity reserves, the insurance premiums, and the like. So this also goes through that budget meeting requirements. You can have the budget meeting in person or virtual, the 115% threshold, 14-day process. And if you do have a substitute budget, it can be adopted by the majority of voting interest. So if you don't have the majority of voting interest, adopt the substitute budget, then the budget as proposed by and adopted by the board goes into effect. Reserves and CEUs funding. So this changed a lot. This actually changed a lot. There were questions as to whether can you fund reserves through special assessment? Can you get a loan to fund your reserves? Do we have to have the cash in the back? What does it mean when we're funding? What does it mean to properly fund reserves? And what is properly funded? So it says that you can fund it through the regular assessment, which means you pay your reserve payment through the regular periodic payment that you pay your regular maintenance fees. You can also fund the reserves via special assessments, loans, or lines of credit, but to do that, you have to have the approval of the majority of the voting interest. So to do alternative funding, so special assessments, loans, lines of credit, those are all going to be considered alternative funding. You have to have the majority vote of the membership. Now, that doesn't mean you need a majority vote from the membership for every special assessment, loan, or line of credit. It means that you need it in order to use those funding methods for your reserves. There also the pooling issue. Now you no longer need a vote of the members if you want to pool your reserves. Now your reserves your pools have to be limited. So you have a CEUs pool, and then you'll have an other reserve pool if you want to reserve your non-CEUs. You want to pool your non-CEUs reserves, so you can change them back and forth. And now you can fund, I'm sorry, the funding may be paused if the building is declared inhabitable for up to a natural disaster for 2 years, or to focus on milestone repair. So you have a 2-year reprieve. If you've just done your milestone, you're going to have a 180, you're going to have a year and a half concrete restoration project. You're going to be spending tons and tons of money for the concrete restoration project. You can have that reprieve so that you're not funding the reserves for concrete restoration at the same time you're paying for concrete restoration. When we talk about proper funding, I'm sorry, I know I'm speaking a little bit quickly now, but I need to get through this. That means baseline funding. What does baseline funding mean? That means that along your schedule, you're going to have enough money to pay for the work as the work is necessary. So if your roof is due in 2030, in 2029 or by 2030, you're going to have enough money to pay to replace the roof. And after you pay to replace the roof, you're not going to go below zero. So you're going to have enough money in those reserves, but your reserves are not going to be depleted 100% just by funding that roof. When you have your reserves, you have to itemize the SERS and the non-SERS items separately. And now reserves is a little bit better because reserves for $10,000 items, especially in huge associations where there are thousands of different expenses, is very low. It's been that way since I've been practicing in this field. Now it's at $25,000, so you can eliminate some of those reserves for the less expensive items, and that will be adjusted for inflation. Now, if you do pause your funding because you're in buildings uninhabitable for some reason, like there's a major storm, or you're in the middle of that concrete restoration project. Once you finish the project, you have to update your reserve study. That can be a financial update if that's appropriate with your reserve provider, because now you need to have the schedule rerun to determine what it's going to be necessary to do the funding, so that reserve item that item that you just completed, the concrete, the roof, whatever it is, will be in the schedule going forward. And then it includes that conflict interest issue again. So see, these are the detail associated with all that. And I'm going through it because I've just already talked about it. And that pause for the milestone, for the work to be performed in the milestone, that only goes through December, for budgets through December 31, 2028. Okay, that talks about this talks about the conflict of interest. So the hurricane protection, very there was a change last year that was very confusing. So unless otherwise provided in the declaration, the unit owner is not responsible for removal or installation of the hurricane protection if it's necessary to be done in connection with another project being performed by the association. So on these concrete restoration projects, a lot of times you have to remove the shutters, obviously, to repair the concrete. And sometimes you need to remove the actual doors themselves because if there's unit invasions, or you need to do restoration underneath the door tracks or what have you. So you have to determine whether or not who's going to be responsible for that hurricane protection. And that's something to possibly appropriately amend your declaration, because you want that to be set in stone before you go forward, before these projects are necessitated. A lot of complaints, a lot of litigation actually as to who bears responsibility for the cost of not only removal and replacement, but sometimes for removal and reinstallation, but for replacing items that cannot be replaced due to their condition or to building code requirements. This happens often. Sometimes the windows, the sliding glass doors are in such a state that the building department or your engineer will say, we're taking them out just so that we can access the concrete underneath or above, but I'm not going to certify this building if you put those doors back in. Depending on the way your condominium documents are written, either the owners or the association will have to purchase new doors, and that's something that you want to know before you go into a major concrete restoration project. For emergency powers, now the association or the board can require evacuation of the property, but if they don't, you're not going to pick them up and carry them out of the building. If they don't evacuate, then you're not responsible for damages for them staying. So if the elevator goes out and the people are trapped on the 27th floor, that's not your fault, because you told them to evacuate and everyone was supposed to evacuate and they didn't evacuate. And now they're on the 27th floor and they have no power and they can't get out of the building. Electronic voting. Okay, so hopefully, I'm a big fan of electronic voting. I think it's super easy. I think it really enables more people to vote. I think it gives people more time to be able to think about how they want to vote on things, especially when you have significant amendments or other proposals like that. And it's just great all around. I think in some cases it can cost less than doing the mailing, the duplication of the mailing of a big thing. Now what happens is the owners, if 25% of the members petition the board to adopt electronic voting, the board has to hold a meeting within 21 days to go ahead and implement the electronic voting. The petition has to be served within 180 days within 6 months of the annual meeting. So basically, you have your vote to elect directors. You know, people may have been happy about the way that the vote count was conducted, so they petitioned for electronic voting, or maybe their votes were not received, or maybe their votes were not counted because there was some kind of defect in the envelope or what have you. They want to vote electronically. They get that petition in. That gives the board time to adopt the electronic voting, hire the appropriate vendor, and then have it in place for the next meeting. But if you don't if you haven't implemented electronic voting, you haven't hired a vendor to do electronic voting, the law says that you must accept ballots via email. And that means you must designate an email address for people to send their electronic ballots. Now, the ballots, there are technical requirements associated with those ballots, and the law does not specifically specify whether the association is responsible for preparation of those ballots that are capable of being emailed. I'm going to tell you what's going to be on them. So, okay, so here's what needs to be on that ballot. It has to be a space for the unit owner to type in his or her unit number, to type her first and last name, which functions as the signature, and it has to have the disclosure that they're waiving the secrecy of the ballot. So does this mean that you have to use PDF forms that are read-write forms? People can actually type in them. Does this mean that you have to send them Word documents so that they make modifications to the Word document and then email it back to you? That's not described. But owners out there, you have to realize if you're going to vote via email without using the electronic voting, then everyone's going to know who you're voting for. So you're voluntarily waiving the secrecy of your vote. And that talks about it again. I talked about this earlier. The authority of the division has been extended to dealing with whether or not you've had your milestone inspections, whether or not you've done the repairs associated with the milestone inspection, whether or not you have the appropriate insurance policies, fidelity bonding, whether or not the board members have completed their education requirements, and the reporting requirements for the structural integrity reserves. Here, we're going to talk about that online account. This is for the associations. October 1, that's coming right up. I mean, that's right around the corner. So you have to have an online account with the division before October 1. And I'm going to show you here that the critical deadline, if you need assistance, you can use this email, and you can send an email to that, entity, that email address, and ask for help, because there's an online portal that is what can help you for creating your online account and linking your managing entity. Every association, every condo association has a managing entity number. So there's a way to go onto the DBPR website, the licensee website, look up the managing entity. That's a number. You'll also need a PIN number, but I do include links to those in a later slide. And here's the information that they're going to ask for. And they're also going to ask for whenever there are changes. And quickly, within 3 minutes, we can talk about the MySafe Florida Condo pilot program, and then I can show you those links. So the MySafe Florida pilot program, fabulous program. This year, it was funded with $280 million. But what I thought, or what I learned, that the applications for the program were exhausted in July. So it was quick. You have to apply for these things really, really quickly. You only need a board vote, a board member approval in order to apply for the inspection. once you have the inspection will come back and tell you what improvements can be made to the building in order to get your mitigation discounts. At that point, you need to have a membership vote. It's now 75% membership approval rather than 100% membership approval to go ahead and apply for the grant. So 100% membership approval, obviously an insurmountable number. Now the board can immediately go ahead and apply for the inspection, have the inspection prepared, then the work is performed, and then you can apply to the department with the grant for the grant once you receive your membership vote. And here this talks about some of the work that you're allowed to do. 11:58. I'm going to have a few minutes for questions. So if you want to hang around for a couple minutes, that I hope you do, and I welcome you to do so. But here's the links that I promised you. So you'll have this presentation. Hopefully the links will work when you get the presentation, and this will show you how to look. Let's see.
You know what I'll do, Lisa, as well, while you're checking with that? When we send out these certificates to everybody within 5 to 7 business days, I'll make sure those links are in the body of that email with the certificate attached. So if anybody can't get it to work with the slides after filling out the evaluation today, they'll have those links in the follow-up email as well.
Okay, good. Well, I just checked it and now I see it on my other screen. So
Sweet.
they are working as far as this is concerned.
Sweet.
So it gives you creating the account. How do you feel? How do you find your managing entity lookout? And then these are the reporting things that were already required, the structural integrity reserve reporting. So we covered everything, had to go a little bit fast in the end. I do appreciate your participation today. And let's take a look and see. There's 77 questions, so I don't know how many.
Just do a handful. The important thing was getting everybody their CEU today. We accomplished that in this complimentary session for everybody. So Lisa will go, she's going to look through a couple of the questions now. While she's doing that, I just want to briefly mention, as Lisa mentioned earlier, the Q&A part is not required, but you're welcome to hang out and stay. In the chat area, not to be confused with that Q&A, but in the chat module, we already placed the evaluation link in there. Go ahead and click on that evaluation link. The site will then open up in another tab in your browser. Fill that sucker out, hit submit. Then you will have the link to download the slides and Lisa's contact information, our event calendar, the whole 9 yards. I'll go over that myself more slowly with a shared screen later after Lisa's done addressing a few of the questions. And yes, Anne, the recording of today's webinar will be on kbrlegal.com within about 3 to 5 business days. We just edit out all the fluff before and after and just get to the meat and potatoes of it. It'll be on the firm website under resources and then webinars and videos. Lisa, back to you, and then I'll come back to help everybody out with the evaluation if you're having problems.
All right, well, there are two good questions here that I really want to address because it's about the electronic voting. One was, what percentage of ownership gives okay to electronic voting? In 55 communities, most homeowners do not have electronic access. So if 25% of your members petition for electronic voting, the board has to implement electronic voting. What that means is that you have to decide on what vendor to use and allow your owners to vote electronically. But that doesn't mean they have to vote electronically. Remember, voting electronically is an option on the part of the owners. And that's another question here. If we've already adopted e-voting and only 80 of the 180 residents have not signed up for it, what do we need to do? Well, you do need to, anyone that does not opt into electronic voting is going to vote the old-fashioned way. So if your members do not opt in for electronic voting, that means you send them the meeting materials via mail, like you would always, or hand delivery, like you would always have done, and they get to vote by mail or hand delivery, like they always have done. So just because you have an electronic voting option does not mean that everyone has to vote electronically. I promise you, once people start getting used to it, then they will be very happy with it because it is so much easier for everything. So there's a question here about when's the yearly budget need to be created? So the law adopted either last year, it might have been the year before, says that you have to adopt your budget at least 15 days prior to the beginning of the fiscal year. So if your fiscal year is January 1, you have to have your budget in place by December 15. But the second part of the question is, well, can a budget be created in the middle of the year for the year that they're in? Now, if you don't adopt a budget, so you're in December, you haven't even thought about it, January, starts your new fiscal year, what's going to happen is that your budget is going to roll over so your payments are going to roll for January and for February, and then say you adopt your budget in March. Well, that March, but when you adopt your budget, you're adopting it for that full fiscal year. So you have decisions to make. Are you going to back bill if there's a differential in the payment? Are you going to back bill your owners for the differential in January and February and March, because you're adopting the budget in March? Or are you going to lump the January, February, March differentials into the remainder of the payments? And there's nothing that prohibits an association from amending their budget mid-year. So you may adopt the budget and then halfway through the year, just realize that it's completely insufficient. You need to adopt an amended budget. You can go ahead and adopt an amended budget. You just need to follow the same procedural requirements. If the board member just completed the 4-hour class, do they need to take the course this year? Really, you take it the year after. So if you just completed the 4-hour class, hopefully your 4-hour class, well, again, this is brand new. So if you took your 4-hour class 2 months ago, you may not have had this information. If you took your class a month, 2 weeks ago, you may have had all this information.
There's a lot of confusion out there about this. Like this class today, all providers like us, it's not just KBR, all the providers didn't get this new class begin to get approved until July 1 of this year. So with that logic on how the division is approving these classes, this course should be good for up until June 30th of 2026, and then we'll have a new one approved for the following year. Like Lisa said, though, after you have taken your 4-hour certification previously. But yeah, I could see where the confusion comes from.
So just a couple more questions. When board meetings are posted on the website, is it accessible by the public or only to owners? Well, obviously that's a decision that you'd like to make, but in my opinion, that should be something that's protected, beyond the password portion of the site. So yes, I mean, your meeting notices, your financial reports, your budgets, and all of your sensitive information should really be beyond the password protection part of the site, because the entire world doesn't need to know exactly when you're meeting and what you're doing. The list of official records that are required on the website. So the comment is, I've heard some attorneys create the list. There's a list right in the statute. We can probably furnish you a list as part of the mail out afterwards. It's a matter of just cutting and pasting from the statute, and I'm happy to do that. Because that's exactly what's required by law. And the bid issue. Okay, so now when board members vote on a contract, the contract needs to be posted before the meeting which the board members are going to vote, so that owners can see what they're voting on. And the question is, what about the bids? Do we have to disclose all the bids to be added to the agenda? So the question is, shouldn't the bids be closed until the contract is awarded? You have two different options here. You can do just a summary. You don't have to post the actual bids. You can post a summary of the bids before you before you award the contract. And then after you award the contract, you can continue with the summary, but I think it's better practice to post the actual bids so that people can see the differentials of what the board considered before they voted on a particular contractor. But that's a good question, because you get all these bids. They could be apples and oranges. They may not be the same. There different considerations associated with them. And then all of a sudden a bid becomes public to members. Members, go running to their service provider if they have a relationship relationship with it, and now your entire bidding process is a little bit skewed. The bids are not secret. I mean, there's not really secret bids. We're not a public entity that's doing sealed bids. But again, it's not necessary to post the entire bid before you let the contract. It's just necessary that you have a summary that indicates that you did obtain those bids and who the bidders were. And how long do you keep financial records? 7 years. Keep most of your records you keep for 7 years, including all your insurance records, and your financial records, and most of the records you're going to keep for 7 years. Now, obviously, your governing documents and your meeting minutes you keep indefinitely. So I think I'm getting the sign here that it's time to. Oops. Oh, I'm gonna stop sharing. How do I? Did you stop the share?
Stop the share, just so that I can share shortly when you're done with the Q&A. I'm going to show everybody how to download the slides and such.
Okay, got
And
it.
your contact information is going to be on the slides that they receive, plus on the post evaluation screen. So they're going to get all that.
Here's a good question. If an owner uses his personal account to record the board meetings and allows others to view that Zoom during the meeting, is that individual's recording required to be posted on the association website? That's the owner's personal property. The law now requires you as the association to make a recording and to post that recording, and that's the official recording. Now, that is an issue with privacy or, handling your internal business, because people can record these meetings. Anyone can record this meeting with their phone, and you don't have control over those recordings. And you're just going to have to accept that, because there's really nothing that we can do for those recordings to be preserved in a way that are not accessible to the general public. So that is what it is. There's a question here. Do recordings of the meeting need to be done if the meeting is only physical? No. And I fear that in many cases, you will have associations limiting what meetings they conduct via video conference because of the fact that you need to preserve the recordings for the year. When you say preserve the recording for the year, that means it's only on your website for a year. That doesn't mean the recording goes away after that year. So the example that we have is with all of those hurricane claims, where minutes of meetings, if they were really, really detailed, or you had the audio tapes of meetings in the past, somebody would complain, my window's leaking. Somebody would complain, hey, there was water, there's water in the garage. There's always water in the garage every time it rains. And then after a storm, when you were making a claim, maybe for windows and maybe for water intrusion into the garage, then the insurance companies would have that information and utilize it to say there were pre-existing conditions and that the issues were not storm buildings. And I want to make this another one clear. The CEUs or the milestone is not applicable, not required for condominium buildings or cooperative association buildings that are only 2 stories high. Now, again, as I said before, you may be in a municipality where they do require a building safety inspection, and that's just a matter of checking with your local building department. I know Delray has it, Boca Raton has it. I think somewhere out in Hillsborough now has it, and possibly the Sarasota area. But I'm very much familiar, obviously, with Miami-Dade, Broward, and Palm Beach, because that's my area, primarily my area of practice. So I want to thank everybody for being here today. I mean, we covered a lot. I know we went a little fast, but you will have the slides that have all of the details, and we'll put together that list of the documents that need to be posted on the website. So I thank you very much for your
Absolutely.